Good morning and welcome to Hearsay. I'm Chris Tritico.
And this is Brian Clary.
713-212-KPRC, 713-212-5772. All right, let's get right back to the phones here. We had Harold on hold. Hey, Harold, thanks for holding through the break.
No problem, sir. The Perry Mason music is very appropriate.
Thank you.
Get you all charged up to ask the question again?
All right, now, tell me.
Is this an order requiring you to appear in court?
Well, basically, it's just an order to appear at a certain time and date. But in our case, we have an assigned judge.
All right, but hang on. I understand you got a visiting judge.
Right.
Some other judge signed just an order ordering you to appear in court on a certain date.
Right, but if I'm understanding when I look up the law and so on, only the assigned judge can legally sign anything in the case since he is assigned.
Well, when did the order ordering you to appear occur, before or after the new judge was assigned?
After.
Someone's going to have to look at it. I'm not exactly sure how you got in this place.
Let me ask you this, Harold. Are you contemplating not showing up because of this?
No.
Okay.
No, I'm seriously considering going back to federal court under 42 U.S.C.'s 1983, 4, 5, 6, and 7 against this.
A civil rights violation?
Against whom?
Oh, yes.
Against whom?
The judges.
Oh, you're not going to win. I think you're.
I'm sorry, sir. I've already run against 3 of them here in Galveston County.
All right. Well, I don't think it's a 1983 violation, but you're certainly entitled to file any lawsuit that you want. And
well, this would more than likely come in under 84, 5, or 6, and I mean you could use 87 to force the judge under 18 U.S.C. 241 and 242 to order jail time for the individual. And that's the question I'm trying to narrow down right now is he the only person allowed to sign an order in our case?
I don't know, because I don't know enough about what's going on here.
Well, I'm just saying if you had
hold on a minute.
Was the judge who did sign the order the sitting judge, and now at a time when a visiting judge had been appointed?
Yes, sir.
Okay.
And in fact, this is not even a sitting judge that we know of. I don't even know where he's at in the court system.
Well, when you're in Galveston County or any other county, you're in the district court, and it's the 152nd or the 234th. You are assigned to a district court. Did the judge that signed the order that you're talking about, is that the judge of that court?
Well, normally we're in the 306, and this is not the sitting judge of the 306.
Okay. There are statutes that say judges can trade benches whenever they want, and I don't know if this is going to fall within that or not. Without knowing more about
I really don't think so with a assigned judge.
Well, that doesn't mean anything. Okay, you've got an assigned judge, but it doesn't mean that.
I don't know that supplants the original judge's jurisdiction unless you're in trial. You can't have the other judge come in without the permission of the parties.
I've gone before when I had a criminal case. I needed a bond set, and the trial judge, my assigned judge, wasn't there. I've gone to another judge. I need a bond, and they signed an order reducing the bond. There's nothing wrong with that.
I'll tell you what.
And so I don't know that this is necessarily a civil rights violation.
In Travis County, if you have a civil case set for trial, you go down on that trial day. You don't know who your judge is going to be until you get down there. They're going to assign you to a court. You won't know until you're assigned what judge is going to actually hear your case. So I don't know that there's a lot there, Harold, but it sounds like you got the federal statutes down, and we wish you luck on it.
Good luck. 713-212-KPRC, 713-212-5772.
Harold might end up in some
Harold.
trouble.
Ken, you're on Talk Radio 950 KPRC. Good morning.
Hi, how you doing?
I'm great.
I have a couple questions. First of all, what is the elements of physical fraud compared to criminal fraud? The reason why I'm asking is
Ken, I hate to do this because I know you've been holding a while, but we can't hear a word you're saying. So I want you to call right back, okay?
Yeah, lift the needle up on the record and put it back
Call
in.
right back. 713-212-5772. Now, we got a couple of emails here that I promised we would do, and then we got Robert on the line. Robert, we're coming right to you, too. 713-212-5772. This is from Dave. I reside in Harris County, and I am creating a revocable trust. Do I need to file a copy with the county clerk or any other entity to make it legal? No. But what you do need to do is make sure that the trust is in the proper form, creating the trust, and a revocable trust and irrevocable trust have different language setting them up. and you need to make sure that the trust documents are on file, if you will, with whoever the trustee of this trust is. In other words, if it's a bank who's going to be handling the trust for you, then they need the trust documents so that they know what the provisions of the trust are.
And please get advice on it if you're not. I
because
I know a lot of really, really great, talented lawyers, and I wouldn't trust 99% of them to do a trust these days.
And if
it changes all the time.
If you're looking for a tax relief, a revocable trust may not be that vehicle for you. Okay, So get some advice before you do this. This is not a situation where I think you can go on the internet and find some form and just do it and expect to get the results you're looking for, especially on taxing issues. So good luck to you. 713-212-5772. Okay, Ken, you're back now.
Hi, how you doing, guys?
Great. All right, try that again.
Okay, I'm not sure where you lost me, so I'll start from the beginning. I am a CPA, and I'm just curious a couple of different things. What is the elements of civil fraud compared to criminal fraud? The reason why I'm asking is, on a person's tax return, first of all, if I understood correctly, he wasn't there, so she had to sign his name, and that she wanted to, it sounds like, what I would say is defraud the government, and that's why I think your advice is very good. You know, you need to speak to someone personally about it, not on the radio.
Yeah.
But I'm curious of, and by the way, she can't go back from a joint tax return to a single. You can go the other way, but you can't go from joint to single. But I was curious of the elements of fraud, the difference between civil and criminal.
Well, first off, I'm not sure if this is a fraud case. If the intent was to cheat the government, then it may very well be fall within the category as opposed to forgery.
I didn't hear that. I don't think they had any intent to defraud the government. But on the difference between the two is not necessarily the elements. It's the outcome. On a criminal fraud, if you're attempting to defraud the IRS out of the money it's entitled to, then you can go to prison for that. On a civil case, if you defraud somebody, in other words, you just have a civil fraud, Brian can address it better than I can, then you are facing losing money at the end of the day.
Well, I understand that, but there are elements of what's the definition of fraud, though. That's what I'm trying to figure out.
No, we can look up the actual elements, but it's typically on the civil side, it's a material misrepresentation intended to induce someone to act, whether to make a purchase or to perform service or whatever the case may be. It's a material misrepresentation. Material being one of the key elements there.
And being an intentional tort, it is you have to intend to do it.
Okay.
It's not a negligence case, and so what I was getting from her was that she and her boyfriend didn't sound to me like they were trying to defraud the government out of their money. They were actually trying to do what they needed to do, and didn't do it in a very good fashion. And if that makes sense.
Well, no, that makes a lot of sense. And on this similar subject, but changing it from the tax return, if somebody doesn't pay your bill and they intended to pay your bill, and they implied the entire time they would, why would that not be an element? I mean, why cannot? Well,
here's the problem with that. The Supreme Court has been very clear about this over the past few years that if you've got elements that may tend to lean toward fraud, but your element of damages rest in contract, here of the fee contract or the agreement to pay, then it's going to be considered a breach of contract case, which may be favorable in many instances because you can collect attorney's fees on a contract case where in this intentional tort of fraud you cannot. And they both have a 4-year statute of limitation, contract and fraud.
But the difference is in bankruptcy, fraud is not excused.
You can't discharge a fraud or an intentional tort in bankruptcy. That's right.
Well, it's got to be considered willful or malicious, I believe, for it to be non-dischargeable. So I'm not sure if fraud would automatically fit into that category.
I appreciate that. Thanks for your time.
Thank you. Have a good day. 713-212-KPRC, 713-212-5772. It's 11:16 on Talk Radio 950 KPRC. This is Hearsay. $10:20 on Talk Radio 950 KPRC. It's Hearsay with Chris and Brian. 713-212-KPRC, 772.
Now, I found a definition of fraud. Now, fraud is a broad category. It means a lot of different things in different states, and it means a lot of different things here as to what constitutes fraud. It's just basically
you being on the radio is one of them. Go ahead. I'm sorry. You're not going to.
You've just become Penn and I'm Teller. I'm not going to say a word. It's generally just to cheat someone. In fact, I had a case with a lawyer here in town that you know very well, who in the pleadings used to say, instead of citing fraud, he would just say cheated. And I think it meant more to the pleading to say that. But in general, common law, 3 elements are required to prove fraud: a false statement made with the intent to deceive, a victim's reliance on it and on the statement, and resulting harm or damages from it. So that takes care of that. Pretty simple.
Go. Yeah, fairly simple deal.
And I'm not sure what the criminal definition is. Probably something close to the same. Of course, as we all know, it's a different burden of proof if you're trying to charge someone with criminal fraud, being beyond a reasonable doubt instead of a preponderance. And the other thing I want to bring up before we get to the next call is, we had a question in the last hour, a person who represented himself and had difficulty getting evidence in court in the trial. And we talked about the rules of evidence. And it struck me that, many people out there may jump to a conclusion that, well, then let's just simplify the rules of evidence. Why are they so technical? And, I want to speak to that because while the rules of evidence there may be some good criticisms of them and where they could be relaxed in certain areas. If you don't have the rules of evidence, how could you ever expect to try a case? You go in there on an auto accident case, and if someone's allowed to get on the witness stand and say, do you have any proof that my client ran the red light? Yes, I talked to 3 people out there at the scene. They all said that the client did it. Well, you can't have that. I can't cross-examine some witness that didn't come to court.
You got to have, you got to have the witness there.
Yeah, and now there are lots of exceptions to the hearsay rule, and we talk about hearsay because that's the predominant evidentiary hurdle that you have to jump. There are many others when you get into, especially with experts and things like that are in the rules, but you have to have some format so you just don't have people coming in and doing like what we're accustomed to on people's court, which is to say, she said, I said, then this happened. That never occurs in a real court. You generally can't do that. So there's a place for it, and everybody's got suggestions about how to change them from time to time, and they do, but they do serve a purpose.
All right, let's see here. Let's take another call before we go back to the emails. We got one holding here. Hey, Robert, you're on Talk Radio 950 KPRC. Good morning.
Good morning. I had an accident on a Metro bus.
Okay.
I was getting up from my stop. It was around 5:30 in the morning, and I got up from my seat and the lady stopped really, really quickly, and I had to grab one of those, stand-up rings to balance myself, and it dislocated my shoulder. Well, they had to call an ambulance, and they took me to the hospital, and Metro took 9 months to claim that they had, their claims department said, well, we're not, responsible for this.
Well, they're saying they're not negligent.
Right.
Yeah. Well, you know what? It's almost standard for buses to stop while people are getting on and off and starting and stopping. And I'm not justifying it. The question is, you can sue Metro. There's no prohibition on that. They're not immune unless something's happened in the last 10 years I don't know about. So if you differ with them, you can file suit against them and see if you can prove that they were negligent. It's not a certainty one way or the other unless you find a statute. If there's a statute in the transportation code that says that a bus shall not move while someone is standing, then you may have what's called negligence per se. But
you have a tougher burden than the typical people suing Metro when the bus has an auto accident, and runs into a car or a pole or whatever.
But so what it is that the jury is charged, barring a statute. Did this driver do something a reasonable, ordinary, prudent person would not have done under the same circumstances? That's your burden, to get them to say, I believe that was below the standard of care. If you do, then you prevail. If you don't, then no matter what your damages are, you lose. So I would talk to a lawyer about it.
Okay.
All right.
Yeah, because one of the things I was wondering about that is, they said they weren't negligent because I was standing while the bus was moving.
But it could be.
I don't know.
Why do they have those handrails for?
Well, because people should be, if they are standing when the bus is moving, they should have already braced themselves and not wait until the bus is stopping suddenly to then grab for it. But again, when you're in a civil case like this, if you sue them, the jury is allowed to compare the relative fault. So what they do when they submit it to the jury is they'll say, do you find from a preponderance of the evidence that any of the parties listed below were negligent? And they'll give the definition of negligence that I gave you a while ago, and it'll have Metro or the City of Houston or however they're named, and it'll have you. And they can say no, yes, yes, no, 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 yes, yes. They can answer it any way they want to. If they answer it yes, yes, that you're both negligent, they still get to compare that negligence. So if the jury says, well, I think you're 25% negligent, but Metro is 75%, you still recover. If they find you over 50%, you're washed out. You don't get to recover. Courts don't allow you to collect money on a case if you're the greater preponderance of the reason for the accident. So it's still comparative, and so your battle there is to get on to be found negligent and to hopefully get that percentage off of you completely, or certainly less than 50%.
All right.
All right. Good luck.
Thank you very much.
Thank you.
Take care.
713-212-KPRC, 713-212-5772.
This is a different accident than a regular when they run into a car, because when they run into a car or something, you have people jumping on the bus, claiming they were on there when it happened.
I was thinking that same thing. All right, this is from before we have to take our bottom of the hour break. If you got a question, give us a call, 713-212-5772. This is from Paul. How do I begin the process of taking someone to small claims court, fees, forms, etc.? I can prove that a gas station sold me bad gas, and it cost me $1,900 in repairs to fix it. Where do I start?
That's a good question for you. You've had a lot of experience with bad gas.
Bad gas, yeah.
You got the expert here, Paul.
Paul, the first thing you need to do is go to the JP court in the area in which either you live or the station, the place where you bought the bad gas is located. Either one will work. I'm assuming they're both in Harris County. If they're not, then I would go to the one where the station is, in the city where the station is. Go into the JP court. It costs, I think it's $45. It may have gone up. I don't know, but.
The filing fee and the service fee is less than $100, I still believe.
And go in there, tell the clerk what you want to do. They will help you fill the petition out. You are suing this gas station, I'm assuming, for negligence in selling you selling you bad gas.
It's also a product liability. So what you have is, I'm assuming your damage is less than $5,000. So when you go in there to fill that out, there's no real stringent pleading requirements. There's a civil form there that they'll let you write into the blank spaces the general nature of it, caused property damage due to selling bad gas. And you don't have to worry about all the intricacies of what the causes of action are and all that, those things. But you just need to do that, get your proof together, and wait for your trial date. Right. And they'll help you serve it. They'll help you do the whole thing. Do that, send that in, and take it on. Take it on from there. It's not a hard process to accomplish. Especially in JP court, because the clerks are there to help you, and the judges make sure that the clerks help you fill it all out. Now, in your instance, because you're alleging bad gas, I think you're going to need an expert, and your expert is in my view the person who fixed your car. All right, but you need to make sure that guy is going to come and he's going to testify that it was the gas that you purchased that caused you the problem. Now, and the problem you're going to have is proving it was that gas. And hopefully, if you have a lawyer, you could probably subpoena to see if they had some other complaints against them during that same time period. That would be very persuasive. All right, good luck. 713-212-5772. $11:39 on Hearsay. 713-212-KPRC. 713-212-5772. I won't be here next week, by the way. Brian, you're going to be here with my law partner, Ron Rainey, but I'm taking the week off. Well, good. Yeah. We should take like a year off. I want to go back in that last call where the guy had a case of the bad gas. Okay. What I was saying at the end of it is that one of the things that can really cause a defendant in a case where you've got a food poisoning or a bad gas or something that might be affecting more than one individual is that when you get into a civil court, now I'm not talking about JP court because the discovery rules are a little different, but if you get into a real court, you're entitled to send discovery over there. It has the same force and effect as a subpoena. You do a request for production, say, produce all documents evidencing, and in this instance, say any complaints arising from bad gas during this, and give a defined time period so it's not overbroad.
And I would also want to find out who they bought their gas from.
Right. And what happens, what's going to really frighten the lawyer on the other side over there is not only would the disclosure of that tend to give you access to a repetitive line of potential witnesses, but it's also
new clients.
It's a repetitive line of potential plaintiffs. And so what sometimes will happen in a case like that is they'll sure get to the bargaining table a little sooner, rather than try to disclose that.
Right. So, and that's another reason why I don't know what his facts are. He says he can prove it. I think bad gas cases are hard to prove, harder than people think they are. He's probably got someone that said it was the gas you bought that did this. But I don't know that person who said that can necessarily prove that it was that gas.
Well, you get into a situation like that. That is considered expert testimony. In the old days, you could just have the old mechanic come in there and say, "I've been doing this for umpteen hundred years, and I know everything about them. And here's the facts." That's not
the rules aren't the same anymore.
That doesn't always work anymore. And if someone challenges that testimony, it can be very effectively challenged.
Right. And so. I know you think you've got the evidence. I would make sure you got the evidence. Okay, let's take a call. 713-212-5772. Hey, Sam, you're on Talk Radio 950 KPRC. Good morning.
Good morning. Thanks for taking my call.
You bet.
This is an issue between my wife and Houston Community College. She took a couple of classes back in 2002, which were paid by financial aid.
Right.
First few weeks of the class, she dropped off. She went back to the financial aid office and told them they wanted a letter from the teacher, which she provided, and they said that was sufficient. Now, we have started receiving phone calls and letters from a collection agency about that. They want that money back. What is our recourse?
What are they claiming? She didn't take the classes?
Well, they want the money back. Yeah, they said that she didn't complete the class as required.
Did she complete the class?
No, she did not.
Okay, well,
she dropped off the first week, and
so when they dropped, had she already paid for the class when she dropped out?
Well, it was paid by the financial aid.
Oh, okay.
Yeah.
Okay.
And so this was a guaranteed student loan, or what?
It was, yeah. It was not a student loan. It was a federal financial aid.
All right. Well, I don't know what the rules are on that. You need to look at the grant she got and see what the rules are with respect to completing the class and or having to pay the money back.
Okay.
And if the rules are that you have to complete the class, then she probably owes the money back.
Is there a statute of limitations?
No, on a federal grant, I'm gonna go out on a limb and say there is no statute of limitations on that. And I don't know the answer to that, but that's my guess. There's no statute on that.
If there is one, it's probably a long one.
Yeah.
So several, 3 or 4 years.
What you need to do is find out what you need to do to resolve this issue quickly and efficiently, because the federal government on these loans and these matters does not go away. Okay? And when you get a tax refund, if you're owed any money on a tax refund, well, guess what? You're not going to get it because the government's going to take it.
Sam, I have a hard time believing that their guidelines are so strict that if you drop out in the first week of class or if you have some other hardship that you can't get out of it, but it may be just a communication issue here. So I would talk not only with the community college, but also the financial aid side of it to try to explain this and see if they're really right in trying to collect this.
She may have had the right to retake that class within a period of time.
Okay.
All right. And that's what you need to find out. Wait a minute. Can I just take the class?
I see. Okay.
All right.
Thanks for your help.
All right. Good luck.
Take care.
Bye-bye.
A lot of people just bury their head in the sand on these things, and the federal government doesn't necessarily want to hurt you, but they do want to make sure that if they gave you the money, you did what you said you were going to do.
This could very well be a communication issue between the financial aid department and the matriculation side of it. Just say, oh no, she dropped this class within a week, and we agreed to this, and maybe it goes away. It may be just a communication issue. It would seem pretty harsh to me that you could sign up for a class and drop it right away, and still have to pay for it.
Right. 713. Oh, I see what you're saying is she may not even owe the money. Right. And so they can get the money back. Turn your mic on.
Yeah.
They can get the money back from the college to pay back the government with. I see. That's a great idea.
Yeah, because it sounded like she had some reconciliation with them as she was dropping it, that they agreed to it. And I don't know why they'd have to agree to it if it didn't have some financial implication there.
Right.
And maybe there's just communication. So I'd talk to both of those offices and see if they can be straightened out.
Right. 713-212-5772. Joe, you're on Talk Radio 950 KPRC. Good morning.
Hey, guys.
Hey.
I got a question for you on inheritance money.
All right.
I don't really want to put that money in the bank. I'm afraid, do the creditors have a way of knowing when you get money like that? And
You talking about your creditors or creditors of the estate?
No, the creditors, credit card creditors and stuff like that.
Well, your creditors?
Yeah, I don't.
Money you owe?
Your creditors don't have the ability to necessarily monitor your bank account, which is what I think you're saying.
And unless they have a judgment against you, they don't have a right to get anything out of that account either.
Yeah, and they would have to go to court and get a judgment. And I would know about that.
Well, there's only one there's only one caveat to that. Let me give you an example. Let's say you had a credit card that you're in default on, and it's a credit card, say, through a bank or a credit union in which you put that money. They could have a cross-collateralization clause in there that says that they can swipe money out of your account if it's in the same institution. But if it's an unrelated credit card and you put it into your unrelated bank, even if they find out about it, they don't have a right to seize it.
Right.
Yeah,
Without a judgment.
See, I'm in forbearance with my mortgage company, behind on my insurance and taxes, and I've got to use that money for that, and I'm really scared to put it in the bank for afraid of these creditors knowing that that's done.
Well, I mean, I all I can tell you is unless it's the same bank, like Brian said. In other words, if you have a Wells Fargo credit card, then your agreement may say that they can go into your accounts at Wells Fargo to pay bad debts.
No, my bank is different from any of the creditors.
Okay, then I don't know how they would have the ability to check your bank account to find out if you had any money in it. Not legally anyway.
We're talking about private credit card companies, private lenders, things like that. Now, the government's maybe a different...
No, it's private credit card companies and so forth.
Yeah, one thing, it sounds like you might ought to talk to a bankruptcy lawyer.
Well, I tried that back in 2004, and I was forced into retirement, so I didn't have the money to complete the bankruptcy. I had it all scheduled out to repay it, but the income was greatly reduced due to the retirement. So I haven't had the money to pay any of those creditors, and there's a few of them been calling me for 3 years now, threatening to take me to court, and they still haven't done anything.
Well, unsecured creditors, and I'm assuming
that's what they are.
Yeah, if these are unsecured creditors, they have every right in the world to sue you.
Right.
That doesn't mean that they will. Time might be on your side if you're 3 years down the road post default to see if maybe the limitations is going to run on that at some point. It's not going to stop them from harassing you.
Yeah, they keep saying the same thing over and over again.
Well, just tell them to quit calling you.
Yeah. I mean, you have a right under federal law to say, don't call me anymore.
Just write a letter to them.
You can write them a letter and say, do not call me.
But they do not have the wherefore, whatever you pronounce that word, to know whether I've got the inheritance and put it in my bank.
They may have the wherewithal to find that out. I don't know.
If they send somebody down to the courthouse to look at the probate matters,
the distribution,
they're not going to pay. They're not going to do that.
But if I know what your fear is, they're going to see this and go, oh, now we need to sue him because now he's got some money. Well, anybody knows that if you file a lawsuit today, you're not going to get a resolution of that for months, and the chances of that money being there is pretty remote. So they still, I don't think that will make you a very attractive target to come after. I mean, they're either going to sue you or they're not, whatever their policy is on collection. And so I'm not sure that you're in that big a jeopardy, but
they ain't done it in 3 years.
Yeah.
They typically don't.
Yeah, there's no money in dumping a bunch of money into trying to collect a debt that they can't collect.
Right.
So,
okay.
All right.
I think time may be on your side if that's, IRS debt, tax debt's different.
Right.
With that unsecured debt, you try to pay it if you can, try to work something out. But if you just flat can't do it and your occupational circumstances is what it is, you just can't do what you can't do.
Right.
Oh, I got one more question.
You're gonna have to hang on then. Hold on. 11:44 on Talk Radio 950 KPRC. This is Hearsay. Talk Radio 950 KPRC. It's Hearsay with Chris and Brian. 713-212-KPRC, 713-212-5772. Let's get right back to the calls here. Let's see here. Hey, Joyce, you're on Talk Radio 950 KPRC. Good morning. Joyce?
Hey,
hi, Joyce.
Help.
All right.
1985, my sister-in-law in Florida made out a will,
right,
leaving me and my 4 kids everything.
Uh-huh.
Well, lady from the church told my husband that she would be a power of attorney to get whatever his sister needed.
Right.
Well,
she stole all the money.
Yeah.
All right.
What can I do?
How long ago did this happen?
Well, we found out in November the 18th when she died.
And how long has this been going on?
Since 2002. My husband went every few years to see about her.
Okay.
But I got sick and almost died, and he hadn't been back since, she died.
All right. And you found out about it when?
November of 06.
All right. And where did this occur?
In Lakeland, Florida.
All right. The first thing I want you to do is tomorrow I want you to call.
Well, we got a lawyer.
All right.
When she died, we found out about the trust.
Mm-hmm.
All this time, she said the trust was to keep from paying
taxes.
Right.
And she never let on that it was for her. But my sister-in-law had $80,000 in the bank, and when she saw it, she had to have it. But she had to get the house to the church. It's a messed up deal.
All right. Well, you got a lawyer there in Florida?
Yeah.
All right. Well, that's the first thing you needed to do was talk to somebody there who knows the law of that state.
Well, she kept putting us off about the trust, and she finally said, well, it wasn't written right, and she wouldn't show it to the lawyer and to the judge. And so the judge made John and my husband
executor of the estate?
Yeah.
Okay.
But he didn't give the house to us. But we went in and cleaned it out and changed locks and did everything. But they came up with, in October of 2006, with a new trust that we got the doctors, and they said no, she wasn't able to sign it.
Okay. Well, here's the deal. You've got this lady caught. You need to. What I would do is, you got the lawyer that's there to help you work through the trust issues.
Yeah.
The next thing that you need to take a look at is whether or not she committed a criminal law violation in the state of Florida. If that's the case, you need to contact the authorities, the Florida authorities, who can help you prosecute this lady for stealing this money.
Well, what if my sister-in-law gave her the money?
Well, I don't know the answer to that.
If she gave it free of her, if she was lucid when she did it, and she wasn't under duress,
and that was her decision, then that's her decision. But
all the promises in the world about what they're going to do through a will only applies with what's in the estate at the time of death. And if the decedent had given things away, there's not much you can do unless you can show she was cheated out of it.
If she took advantage of your loved one and stole that money, then the authorities will help you out with it, okay?
Well, I can't prove it, though.
Well, that's what the courts are for.
Yeah, it is very difficult to prove what happened in conversations and interactions with someone that you weren't present for. But there's certainly ways to investigate that to see if you can come up with evidence of that. There's lots of you could talk to her friends, people who were seeing her every day.
Well, we talked to talked to her neighbors, and this lady kept her neighbors away from them, and she was in a rest home for a week or nothing, and she said she didn't have any relatives.
Well, a good lawyer that does these types of will contests and other estate type things, they know of ways to try to prove it. Sometimes you can get there, sometimes you can't, but you need to really talk to your current lawyer about how to pursue that.
Well, what do you think about writing a college to tell them what she did?
Write a college?
She gave the house to a college.
Well, I think that's one thing that but you need to talk to your lawyer. And I don't think you need to be doing anything until your lawyer sanctions it, because.
Well, he suggested it.
Huh?
He suggested writing a letter to the lawyer.
Well, I think you need to
college.
make sure you understand what the advice is by your lawyer. Ask any questions you have. At the end of that, if you're in agreement with that suggestion, go ahead and
do it.
Do it.
Yeah.
Well,
okay.
in other words, we're out of luck.
No, nobody said that.
You may be, but you've got you've hired legal counsel in this case. I think you need to sit down and see what's been done, what they're suggesting for the future. Talk about ways of trying to establish whether or not your loved one was competent at the time of these transfers.
Well, my husband went down in 2002 to bring her back because he said she wasn't of sound mind.
Okay. Well, you need to talk to your lawyer and find out what he's done and what he recommends that you do. Okay? And if he said send that letter, then let him help you write that letter. Okay? Good luck. 7 more. I'm not giving the number out. Let's just take another call. Hey, Lewis, you're on Talk Radio 950 KPRC. Good morning.
Hey, guys, got a question here.
All right.
My father died a couple of years ago, and last year we sold the house. And the house was actually 2 tracks all surrounded by a common fence.
Hey, can you, Lewis, hang on. I skipped a break. Just hang on. I'll be right back.
Sure.
11:53 on Talk Radio 950 KPRC. This is Hearsay. All right, let's get right back to the calls before we run out of time. Hey, Lewis, you're back on Talk Radio 950 KPRC. Good morning.
Good morning. Make it quick here. There are 2 parcels in the transaction. There was the house, and then there was a little lot to the side. They were all surrounded by one common fence. Anyway, I started getting tax bills for the little small parcel, and then I looked in the deed, and the fence did not include both. There's the legal descriptions for both pieces of property are not included on the conveyance.
All right.
And just wondering, the transaction was supposed to be both, and I'm just wondering who screwed up and who has to pay to fix this.
Was there a title company involved?
Yeah, there was a title company involved.
That's who I'd talk to first.
Yep.
Because you have to look at your title commitment and see what they were accepting in and accepting out. But I'm assuming the closing and the contract that they were acting upon was for the sale of both parcels.
Yeah, it was, but the problem was it only had the address, the common address up there at the top.
Let me put it to you this way: try to find the original owners of it, whoever the title holder is, and contact them as well. See if you can get them to deed that over. And if they say no, tough luck, your mistake, then you may have to sue them for specific performance. But you might want to start with the title company first.
Right.
But at the end of the day, if you had a contract for that and due to mistake it didn't get conveyed, I think you have a right to sue them for specific performance to get that conveyed.
Okay. Thank you.
All right. Good luck.
Good luck on it. I don't know why they wouldn't just sign the deed.
Yeah. I mean, why go through all the trouble? And the expense that you're going to have to do when you don't need to, unnecessarily.
Mm-hmm.
But, that's what litigation's all about, Brian.
That's why the lawyers make the money. But, you got to look at it is, having gone through a closing here recently, it's amazing. You really can't take for granted what the realtors, what the title company is doing. You got to read that stuff, make sure that you're getting what you're supposed to get, and look and see what they're excluding out of it.
You told me after you did that closing that you would never go to a closing again without a real estate lawyer.
I'm not.
And we're lawyers.
And I actually had a lawyer look at this before I went to the closing, and I wish he had been there at the closing when I had to sign upwards of 35 pieces of paper.
Yeah. And
they're trying to rush you through there. You don't have forever, and you're sitting there trying to read this stuff. And, there's all kinds of things. And some are very common, and some are customary.
Right.
Some are unique to the lender. Some are unique to the...
You had a lot of things taken out that the lawyer told you. Tell them to take that out, and they took it out.
Exclusions in the title policy.
Right.
And just don't take it for granted because you got a title policy that everything is just the way you want it to be. Look in there and see what they're excluding out.
Right.
Insurance policies are great for what they cover, but they're more important about what they exclude.
What they don't cover.
Right.
And that's what people don't read.
Yeah. So,
all right, well, that's it.
I've learned my lesson.
I won't be here next week. It'll be Brian and Ron Rainey. I'm taking the week off. You just heard 2 hours of Hearsay with Chris Tritico and Brian Clary. It's only right here on Talk Radio 950 KPRC. Stay tuned for Dr. Joe Galati and Your Health First. What's left of it, have a great weekend.